We now begin session 1 under the title, Duty of Cooperation under the UNCLOS regime. For this session, we have Professor Pierre Baudot-Livinet as the moderator. Professor Livinet is joining this conference virtually from France. Professor, are you with us?
I am with us. Hello, everybody.
Now I'd like to hand over the microphone to our moderator to begin the session 1.
Thank you very much, and hello from Paris. It's early morning in Paris, so I probably should say good morning, but also good afternoon and good evening, and probably even good night for a few of you. I'm very pleased and honored to moderate this first panel of the KCIL conference. It's always a pleasure to participate in that conference, usually in Seoul, and I hope we will have the opportunity to all meet again in Seoul. But I must say that given the circumstances and on a personal note, I would say that it's important that we keep going, and in that sense, the efforts made by the Korean Society of International Law to maintain that conference on this very important topic this year is, I think, really to be commended, and I want to thank them for that. We have a very busy panel this morning, so I won't take long because my main role will be to stick to the time and to have the panelists kindly sticking to their time too. So I'm not going to make a long introduction. We have today 5 speakers, or 3 speakers and 2 discussants, which I'm going to introduce in a minute. I would just like to say first that it may, I don't want to be critical because I'm not critical at all of the program, but in a way, for those of us who are not experts in the law of the sea issues, it may even be strange to open up a session on the duty to cooperate. After all, the duty to cooperate is at the core of every treaty or every multilateral treaty. You know, it's the bottom line of every treaty. But, and that's why I'm not critical at all, I believe that the duty to cooperate has a very specific flavor as far as the United Nations Convention on the Law of the Sea, the UNCLOS regime, is concerned. It is, in a way, the engine of the convention. We have to I say to my students, at least, that the treaties are not only legal objects. They are living items, treaties, and they have a dynamics. And the duty to cooperate is, I think, at the core of that dynamics. And this is what we're going to explore today from the perspective of the judges, of the academics, from the perspective of the regime itself, as we shall see. The program of this session is the following one. The first panelist this morning will be Judge Kulyk from the International Tribunal for the Law of the Sea. Judge Kulyk has just been re-elected for a new term at the tribunal, so I should congratulate him very warmly for that. He comes from Ukraine, and after a long career at the diplomatic service in Ukraine, he has been a judge at ITLOS, and he will intervene on the topic on the contribution of the tribunal and of ad hoc habitual tribunals to the advancement of the duty to cooperate under the UNCLOS regime. Then my good friend, Professor Niloufer Oral from Turkey, who is a professor now at the National University of Singapore, which is she's the director of the International Center at Singapore, and also, of course, as we all know, a member of the International Law Commission, will deal with the duty to cooperate under Part 12 of UNCLOS and the protection and conservation of biological diversity beyond national jurisdiction. Then, as far as the speakers as concerned, Professor Seoko Lee from Iha University will deal with UNCLOS and the obligation to cooperate, an international legal framework for semi-enclosed seas cooperation. Professor Seoko Lee is a pillar of these conferences. It's always a pleasure to see him in Seoul, and I should also greet him as the co-chair of the ILA study group on the Asian practice of international law. And I say that in a bit of a selfish capacity. I hope Professor Lee will not mind, because in my functions of ILA Director of Studies, we have just launched the biannual conference, and actually the study group on the Asian state practice will hold a session, an open session on 11 February. So you're all invited to join and to register and to join. Then we have two discussions for this session. The first one will be Judge Oscar Cabello from Paraguay, who has been a judge at ITLOS since 2017, if I am not mistaken, after a long career in the diplomatic service. He was a vice minister for foreign affairs until 2017, and he is, I believe, in Paraguay, where there is currently a storm. So we have all fingers crossed and hope that he will be able to stay with us for the whole conference. And finally, last but not least, I don't really like this expression, then I'm very happy to greet my good friend Yoonjung Kim from the Yonsei University. Yoonjung did her PhD in Paris, in France, and in French, and fantastic PhD, I must say. She knows that I have always appreciated her PhD, and she will be discussing also the three panelists. With no further ado, I've already spoken for turn. I think I should give the floor to Judge Kulyk for 20 minutes. The floor is to you, Judge Kulyk.
Thank you. Thank you, Professor Levinek. Good morning and good afternoon for those who are in Korea or in Singapore. I hope everybody are hearing me.
Yes,
clear.
we do.
So let me also start with expressing my thanks to the organizers of the conference, not only for the opportunity of sharing my views on this important subject, but also for maintaining this international gathering and trying to organize the conference in such complicated circumstances of the pandemic. I believe their efforts deserve our wholehearted support and appreciation. And I hope, and I'm looking forward for the interesting conference and exchange of views. The focus of today's conference is on marine environmental protection. Hence, my presentation will be mostly limited to that context. It will start with a brief survey of the notion of the duty to cooperate in the provisions of the Convention, in particular concerning protection and preservation of the marine environment. Then I shall look into several decisions of the International Tribunal for the Law of the Sea, which have enriched the understanding of the duty to cooperate. For the sake of time, I will limit my presentation only to the Tribunal and leave the ad hoc tribunals maybe for the other discussions in other forums. The duty to cooperate is a well-established principle of international law, and in our days has been viewed as a linchpin for the peaceful relationship between states and the key element of the protection and preservation of the marine environment. Although the Convention does not contain a specific article stipulating a general duty to cooperate, cooperation penetrates the logic of the whole document. The very first paragraph of the preamble recognizes the desire of the states parties to settle in a spirit of cooperation all issues related to the law of the sea. The notion of cooperation is referred in dozens of articles of the Convention. The most relevant from the viewpoint of this presentation being those concerning cooperation in protection and preservation of the marine environment and in conservation and management of the living resources of the ocean. The Convention also repeatedly offers guidance on specific measures how to exercise the cooperation. These measures often include regular notifications and consultations, systemic exchange of data, coordination of research, monitoring programs, and etc. And I will talk about it a little bit later in my presentation. In addition to the clear term shall cooperate, such expressions as shall promote international cooperation may cooperate, with some clause varieties like shall endeavor to cooperate or shall endeavor to meet are also used in the convention. Cooperation also may be implicit in other provisions, for instance, those imposing obligations to promote, establish, or even promote the establishment. However, again, in my presentation, I'll mostly stick to the express references to the duty to cooperate in the convention. The convention sets forth a comprehensive legal framework for protecting the marine environment from all sources of pollution, including pollution from dumping, from vessels, seabed, and land-based activities. It creates an unprecedented regime for marine environment protection that compels parties to cooperate in addressing issues of common concerns, and what is important, contains a mandatory dispute settlement procedures with binding decisions. The substantive provisions relevant to the marine environment comprise Part 12 of the Convention. As stressed by ITLOS, the states parties' obligation to protect and preserve the marine environment is a fundamental principle underlined in Article 192, 93 of the Convention, and referred to in the 4th paragraph of the preamble. The obligation in Part 12 applied to all states with respect to the marine environment in all maritime areas, both inside the national jurisdiction and beyond it, and irrespective of where the alleged harmful activities are taking place. The importance of cooperation to marine protection and preservation has been recognized by the Tribunal in several cases, in particular in the Mox-Planck case, in the land reclamation case, and in the advisory opinion submitted at the request of the Sub-Regional Fisheries Commission. I will refer later in my presentation as SRFC advisory opinion. Although phrased in general terms, as noted by ITLOS, it is well established that Article 192 imposes a duty on the states party to protect and preserve the marine environment. Its content is informed by other provisions of Part 12 and applicable rules of international law. This general obligation extends both to protection of the marine environment from future damage and to preservation in the sense of maintaining or improving its present condition. Taken together with Article 192, the duty to cooperate in protection and preservation of the marine environment thus imposes at least two general requirements: positive, to seek collaboration towards protection and preservation of the marine environment, and negative, to moderate unilateral actions which may damage the marine environment or prejudice the interests of others. Part 12 lists a series of measures to be undertaken in order to meet these requirements. Among the most important are notification of imminent or actual damage to other states likely to be affected, joint development of contingency plans corresponding to pollution incidents, promotion of studies and scientific research and programs, exchange of information and data, as well as establishment of appropriate international rules, standards, and scientific criteria for marine environmental protection. In this context, I would also include the conclusion of international agreements. A reference can be made to Article 243, which explicitly provides that states and competent international organizations shall cooperate through the conclusion of bilateral and multilateral agreements to create favorable conditions for the conduct of marine scientific research in the marine environment. Furthermore, pursuant to Article 244, paragraph 2, states are required to actively promote the flow of scientific data and transfer of knowledge resulting from the marine scientific research, especially to developing states. The International Tribunal for the Law of the Sea, in its SRFC advisory opinion, emphasized this obligation as particularly important for the conservation and management of marine living resources, since reliable data concerning species to be harvested would be a prerequisite for the establishment of an effective management scheme. These measures indicate that implementation of the duty to cooperate in the Convention is foreseen primarily at the international level. However, the implementation of the duty to cooperate could not be considered complete without the proper actions at the national level. Such actions by states would include policy guidance for government organs, adoption of appropriate legislation, and certain level of administrative execution in order to ensure compliance with the applicable international rules and standards. And here again, I could make a reference to the International Tribunal for the Law of the Sea, which in its SRFC advisory opinion stated that the flag state had the obligation to adopt the necessary administrative measures to ensure that fishing vessels flying its flag are not involved in activities which undermine the flag state responsibility under Article 192. The duty to cooperate in protection of marine environment gives rise to a number of procedural obligations, such as to consult, to regularly exchange data and information, to notify on the nature of the activity and on the risk involved, and to conduct the environmental impact assessment. They are instrumental in ensuring that the substantive decisions to be reached will take into account anticipated environmental harm and the interests of affected states. Notably, in land reclamation case, the tribunal specifically placed the requirement to prepare as soon as possible an interim report on the subject of infilling works. In fact, now an environmental impact assessment in the context of the duty to cooperate. These procedural obligations also enable the states concerned to evaluate the impact of the expected activities of the marine environment, to submit objections or complaints, and to take remedial measures if necessary. Once submitted, the objections or complaints cannot be ignored without legal repercussions. Under the Convention, these procedural obligations are of independent character, and in compliance with them could be established notwithstanding the manifestation of damage to the marine environment. Issues of the marine environment protection have been present in several proceedings before the Tribunal on the Law of the Sea, in particular in 3 provisional measures and 2 advisory opinions. ITLOS, on a number of occasions, has stated that the duty to cooperate is a fundamental principle in the prevention of pollution of the marine environment under Part 12 of the Convention and general international law. Moreover, in southern bluefin tuna cases, the Tribunal expressly acknowledged the conservation of the living resources of the sea as an element in the protection and preservation of the marine environment. It also concluded that under Article 64, read together with Article 116 to 119 of the Convention, states parties to the Convention have the duty to cooperate directly or through appropriate international organizations with a view to ensuring conservation and promoting the objective of optimum utilization of highly migratory species. In the Mox plant case, the parties were prescribed to cooperate and for this purpose to enter into consultations in order to exchange further information with regard to possible consequences arising out of the commissioning of the Mox plant, to monitor risks or the effects of the operation of the plant and devise measures to prevent pollution of the marine environment. In the land reclamation case, the parties were ordered to cooperate for establishing mechanisms to exchange information and assess the risks or effects of land reclamation works on the marine environment and to propose measures to deal with any adverse effects of such land reclamation. Similarly, again, in southern bluefin tuna cases, after stressing the need to intensify cooperation, the Tribunal again ordered the parties to resume negotiations without delay with a view to reaching agreement on measures for the conservation and management of southern bluefin tuna. All these cases, or actually with reference to all these cases, it could be suggested that in view of the ITLOS, consultations, exchange of information, monitoring and assessment of the risks and effects of relevant activities, as well as development of measures to prevent pollution or other environmental harm, inform the content of the duty to cooperate in protection of the marine environment under the Convention regime. These procedures and measures offer a basis for the implementation of the duty to cooperate, and or as well as criteria for determining compliance. As noted by some commentators, the mentioned cases also indicate how obligations of cooperation in prevention and controlling of environmental harm can be enforced using provisional measures proceedings of ITLOS. I believe a useful tool which state parties can bear in mind in dividing their strategies to tackle the environmental dispute. In the SRFC advisory opinion, ITLOS specifically discussed the nature and scope of the duty to cooperate in the context of shared living resources. The Tribunal concluded that cooperation between the states concerned on issues pertaining to the conservation and management of shared fisheries resources, as well as promotion of the optimum utilization of those resources, is a well-established principle in the Convention, reflected in several articles, namely 61, 63, and 64. Noting that Article 63 for straddling stocks and Article 64 for highly migratory stocks impose a duty to cooperate with competent international organizations, ITLOS stated that the duty to cooperate requires coastal states fishing for straddling and highly migratory stocks to take measures consistent and compatible with those taken by the appropriate regional organization. Thus, the duty to cooperate in the field of conservation and management of living resources entails participation in and compliance with the conservation and management measures of the regional fisheries management organizations, inter alia, through adoption and implementation of relevant legislation, and for a flag state also through effective control over vessels. ITLOS further observed that the duty to cooperate under Article 64, paragraph 1, require the states concerned to consult with one another in good faith pursuant to Article 300 of the Convention. The consultation should be meaningful in the sense that substantial effort should be made by all states concerned with a view to adopting effective measures necessary to coordinate and ensure the conservation and development of shared stocks. The Tribunal also clarified that in order to secure the effectiveness of the conservation measures that states members of fishery management organization may apply, under Article 64, they have the right to require cooperation from non-member states sharing the same stocks or whose nationals fish in the region. Thus, as far as shared marine living resources are concerned, the duty to cooperate under the Convention encompasses the right to seek cooperation from all states having an interest in such stocks, irrespective of their membership in the Fisheries Management Organization. Dear colleagues and distinguished members of the panel, as a conclusion, let me sum up by observing that the states parties have a positive obligation to cooperate in protection and preservation of the marine environment, pursuant to the relevant provisions of the Convention, and need to implement a range of actions to this end. ITLOS, in its jurisprudence, not only affirms the general purpose of the duty to cooperate, but has consistently interpreted it as comprising a number of specific obligations, including to consult, to exchange information, to monitor and assess the risks and effects of relevant activities. In addition, it may be suggested that under the Convention regime, duty to cooperate can mean different things in different contexts. Consultations, exchange of information, scientific data and knowledge, monitoring, evaluation of risks and effects of relevant activities, including obviously environmental impact assessment, development of contingency and other measures to prevent pollution, inform the duty to cooperate in the context of the marine environmental protection. While in the context of conservation and management of living resources, the duty to cooperate would also encompass participation in the relevant fishery management organization, implementation of its conservation measures, as well as to seek in good faith an agreement with other states on fisheries matters. With reference of the earlier practice, I could also say that there is merits in decoupling of procedural obligations within the duty to cooperate with the marine environmental protection. This decoupling separates specific procedural obligations requiring compliance before the damage to the marine environment occurs, or when establishment of such damage is difficult to ascertain. In general, the importance attached by the International Tribunal for the Law of the Sea to early communication and coordination shifts the fulfillment of the duty to cooperate towards prevention of the harm to the marine environment, and, in my view, offers a basis for the evaluation of the compliance. I thank you.
Thank you very much, Judge Kulyk, for a really insightful and very substantial presentation, and also for sticking very strictly to the time. I will refrain from asking any question, although I have some comments to make for the sake of discussion. But because of the time, I think that the best would be that I give the floor to the second speaker straight away, and then after that we will open the floor and listen to the discussion and maybe have a chance to discuss all together at the end of the session.